Our third and final case on the docket today is Dorothy Hauser versus Goodwill Industries of Southwest Florida. Counsel, if you're ready, you may proceed. Thank you.
May it please the court, my name is Bill McCabe. I represent the claimant, Dorothy Hauser, and I'll reserve 3 minutes for rebuttal. In this case, the judge of compensation claims denied claimant's claim for temporary partial disability benefits because he found claimant was terminated for misconduct. The misconduct termination is based solely upon alleged derogatory statements claimant made to another employee about people from Mexico, to which no witness testified and which was placed in evidence through the introduction over objection of this exit interview form. Now, we submit the judge erred in allowing the exit interview form in evidence actually for a couple of reasons. They put it in evidence under the business records exception to the hearsay rule. And that rule provides, that statute rather, 98036A provides that even if the proper predicate is laid for that rule, it's still not admissible if the sources of information or other circumstances show a lack of trustworthiness. And we submit in this case, there's a clear lack of trustworthiness in connection with the...
Counsel, I've got a kind of a broad question for you. I noticed in your brief you wrote that this issue is reviewable de novo. Because even though it's an evidentiary issue, it's what the definition of hearsay is. But isn't a judge's finding on whether evidence is trustworthy or not, or lacks trustworthiness is what the statute says, isn't that kind of by its nature something that is discretionary on the part of the trial judge?
I would agree with you on that. I would agree probably the first argument I'm making about the trustworthiness probably would be a decision for the judge to make.
But you still believe that it was an abuse of discretion on that?
I think that would be the proper,
okay.
I would agree with you on that. My second argument, though, whether the comment in the business records is still hearsay, I think would be an issue of a matter of law. But as to the first issue, the statement was purportedly given to a Jane Jordan, who's the district manager, from a customer on the telephone. And the customer purportedly told Ms. Jordan that she overheard claimant make a derogatory comment to another employee who was the cashier. Now, here's why we think it's untrustworthy. The first thing is the customer purportedly called Jane Jordan and left a message on her voicemail. Well, no one else heard the voicemail. Voicemail wasn't saved. That's number one. Number two, Jane Jordan testifies that she personally spoke to the customer and she did write the name and phone number of the customer who called. However, she can't find that note. She can't find anything about it. So we don't know who the customer was. We don't know the phone number, nothing about the customer. Next, the customer who called allegedly stated that they heard the claimant make this comment to another employee who was the cashier. No one, Jane Jordan, nor anyone else, ever talked to this cashier who's a co-employee. I mean, it just makes no sense. You wouldn't go talk to the cashier. Then the fourth thing is she never talked to the claimant about it until 21 days later when she came and fired the claimant. So, I mean, you've got an uncorroborated person calling in. 21 days later, you fire the claimant over it without ever even getting the claimant's side of the story. You never even talk to a co-employee. I mean, to me, that just smacks of untrustworthiness of allowing this exit interview form into evidence.
Of course, they probably accepted it the way it was because it was kind of a pattern on the part of your client to make these types of comments. You received 2 corrective action notices, correct? I said that right.
Well, she had 2.
Prior to this, involving somewhat similar comments.
One of them was about similar comments, yes. The other prior corrective action was because she didn't put cash in the safe overnight, something like that. But, we didn't even discuss or challenge those prior 2 because that's not why she was fired. I mean, after those prior 2 she stayed on the job, and so the basis of her termination was this final alleged incident. Now, the second portion of our argument on this is that even if this exit interview form gets into evidence under the business records exception, the comments made in it are still hearsay. It's double hearsay. And in order for a double hearsay comment to get into evidence, it also has to be an exception to the hearsay rule. And I think here's the key to this is, okay, we've got the declarant, who's the unknown, unidentified customer. And the matter asserted, I think this is the key to this, and I actually took myself a while to get my head around it, but the matter asserted is not the derogatory comment. It's what the claimant said. That's the matter asserted by this unidentified declarant.
Let me ask you a little bit of a broader question. Suppose I'm in retail, I'm a manager, and I hire someone, and over the course of the next 2 weeks, I get 10 calls from customers complaining about the rudeness and demeanor of the employee. And, after the 5th call, I say, well, this just isn't working out, and I fire the person. And say there's some kind of a claim, unemployment compensation, workers' compensation, where I have to prove that they were fired for misconduct. Can I not prove misconduct unless I'm able to identify all of the customers who called? In other words, I bring the manager, and the manager says, all these people called me. But I can't prove misconduct unless I bring in the actual customers?
You would have to bring in at least one person to testify, because otherwise it's hearsay. And as a matter of fact, a couple of the cases that are cited in the brief is even in the unemployment cases, you can't find misconduct based purely on hearsay.
And following up on Judge Winokur's question, isn't a distinction here as to whether the claimant admits or denies the accusatory language or the behavior? If we distinguish Sears from this case, the difference would be that the claimant in Sears said, I did it. I committed the act. That was the basis for my termination. Here the claimant says, didn't happen, never happened.
Absolutely.
In Judge Winokur's situation, if the employee said, yes, I committed those acts, but I don't think I should be fired, isn't it a distinguishing factor whether the claimant admits or denies the conduct?
It's a huge distinguishing factor, because you're right, the Sears case, that's what happened, is the employee stated, yes, I did do these things. In this case, the judge makes a finding, says that she did agree to it, but she did not. Right on the exit interview form itself, she writes, this is not true. I would not have had this conversation. And then in her deposition at a trial, she says, I don't know if it might have been the situation. If it was, I never made that statement. The customer one time said that you need to learn how to speak Spanish if you're going to work here, and she explained that the customer was an angry customer because the customer before that customer only spoke Spanish and no one working for Goodwill did, so it took a long time, so the customer got frustrated. But she never admitted that she made these statements. So you're right, that's a huge distinguishing factor in between this case and the Sears case that the judge of compensation claims relied upon.
Counsel, does the form of the customer complaint matter? So let's assume hypothetically that there were 5 customer complaints in writing with the name of the customer, the day they visited the store, and the specific statement made by the declarant.
It's still, unless you bring one person, it's still all hearsay. Now, if all that had happened, I wouldn't have made the trustworthiness argument, because now here's somebody that perhaps, claimant's attorney could contact and find out if this really happened. And it would have been no problem for the employer herein to do that, because the comment made by the claimant was allegedly to another employee who was never even contacted by the employer. I mean, I really don't understand that at all. But I think the key, too, is they're claiming the statement made by the unidentified customer is not hearsay, because they're saying that they're not trying to prove the allegations of the statement that the claimant made, but what they are trying to prove is that the claimant said those words. That's what they're trying to prove. That's the matter asserted. That's why it makes the comment that the unidentified customer said hearsay. And I cited that one federal case in my reply brief. I didn't find it until I did my reply brief, but T. Harris Young Associates versus Marquette Electric, and they talk about hearsay in there, and it nails it. It's the matter asserted. They're claiming the claimant said it, and the claimant says she didn't say it, and without evidence that the claimant said it, there's no evidence of misconduct on the part of this claimant. They can fire the claimant if they want to, but that doesn't raise it to the level of misconduct.
Let me shift gears just a little bit, make sure I understand procedurally what happened here. So the employer offers this exit interview form into evidence as evidence of misconduct.
Yes.
You object on hearsay grounds. The judge overrules the objection and admits the form.
Yes.
So if we decide you're right, that it was hearsay and inadmissible, what's the remedy?
The remedy is the judge's decision gets reversed and remanded to the JCC for award of temporary partial disability benefits.
Wouldn't it be remanded for a new, normally when we reverse because improper evidence was admitted at trial, we reverse for new trial.
Well, the reason...
Why would we not do that here? And let me explain why. Suppose, again, this is just supposing that we reverse. Surely the employer here would be able to say, bring in that cashier and have non-hearsay or at least admissible evidence to prove this. I mean, that's the whole point, is the employer didn't do anything wrong. They offered evidence. The evidence was admitted. If they were wrong, they get another chance, and they may want to present admissible evidence to do so. So why wouldn't we, that's the way, my understanding is the way we normally do it. Why wouldn't we do that here?
Because you get one day in court. They had their opportunity.
Well, except when inadmissible evidence is admitted,
Well, that's the only
you
evidence.
remand for new trial.
It's the only evidence they presented in this case to try to show misconduct, and it shouldn't have been admitted. Without
So
that,
we should start just reversing judgments and ruling the other way just because improper
I don't
evidence
know
was
why
admitted?
somebody would get a second chance. You got your one day in court, so now we got to go back. The judge made a mistake, so now we've got to go back and now give the employer carrier an opportunity to cure the mistake that they made by not bringing the
Well, they made the
catch.
mistake because the evidence was admitted. If the judge had done the right thing, again, assuming that it's hearsay, and denied it, then they might have been able to get proper evidence in, such as the cashier's testimony.
Well, it happened at trial. Let's take that. Let's suppose the judge made the right ruling in our viewpoint and did not allow the exit interview form into evidence. Then the judge would have ruled in favor of the claimant at that hearing.
But they would have had the opportunity to put in other evidence,
How?
such as the cashier.
Everybody was already at trial. This occurred at trial. And they
There
didn't
wasn't a
have,
pre-hearing motion.
beg your pardon?
There wasn't a pre-hearing motion on it, which certainly could have occurred. And also, it's my understanding from the transcript that the judge actually reserved ruling on the objections and didn't make a decision until the order, or at least conclusively until the order was issued.
That might, to be honest, Judge, I don't remember that specific detail, but my point would be that you're at trial. If the judge had ruled in claimant's favor like she should have, or he should have, excuse me, then the claimant would have been awarded TPD benefits at the conclusion of that trial because the judge rejected all their other defenses. This is the only defense the judge, better save my last minute in case I need it.
Thank you,
Thanks.
counsel.
Morning. May it please the court, Scott Beatty on behalf of the employer carrier, Goodwill Industries. This is a pretty narrow issue, and the claimant concedes that the business record exception was met. That's not in dispute. The issue that they raise is twofold. Number one, that it shouldn't have come in because of this exception to the business records exception about a lack of trustworthiness, and then they argue that the form itself, or this business record, contains hearsay within hearsay. On the issue of trustworthiness, Judge, you're correct. The standard of review on that, based on the case that I've cited, is an abuse of discretion. And the judge's determination or ruling on that is based on his overall weighing of the credibility of the witnesses, which gets into this other issue about hearsay. They had the burden of proof to show that it was untrustworthy, and again, I don't think that there is an abuse of discretion with respect to that, the way that the document was created. They had 3 individuals testify. They had the Ms. Jordan, who's the one who took the call. They had Vicki Clay, who's the regional manager who signed the form and conducted the exit interview with the particular witness. As you noted, she had 2 prior instances of using inappropriate racial comments with her supervisor and store customers. And Judge Thomas, to address your point on the timing, I do want to, the exit form was after she was being notified of her termination. So you had asked a question about whether she had admitted or denied and the distinction that raises with the Sears case. Now, the earlier incident report that happened in 2016 that references the 2 different, racial incidents, the one with the supervisor that she used the N-word, and then the other one where she complained about Mexicans, there was no dispute. There was nothing noted on that particular file by the claimant that says, I dispute this. In fact, she scratched out a couple words and changed the words, but she didn't dispute that any of that happened. So now we get to this, and they say, by the way, this is your last warning. So then they get a phone call from a customer saying, I overheard another similar racial discussion. The reason it takes 21 days, as was testified by these the supervisors, is they don't take, it's Goodwill Industries. They don't take and want to fire people, in the way that may be a regular for-profit business. Goodwill is there to serve and provide jobs for people in the community. So the reason it took so long is they wanted to decide, again, the testimony is that it took them some time to figure this out. Well, so then they come and they present this form to her that says, by the way, we're terminating you. And she says, I never would have said that. And what the judge of compensation claims says is there had been testimony before during her deposition and at trial where she says, well, if I kind of remember that there may have been a discussion, but I never would have said that. And the judge of compensation claims says, well, of course you're going to say that. When you're presented with your pink slip that says you made a comment, an inappropriate comment about Mexicans or other minorities, of course. That's a classic weighing of the credibility of witnesses that the judge of compensation claims as a trier of fact is entitled to perform. So, and that again, that kind of ties into the trustworthiness aspect. With respect to the hearsay within hearsay, it is very important to understand that, again, we have a business record that they claim, there's no challenge, to the fact that the predicate for a business record is laid. The only issue then is it contains hearsay in there. The hearsay statement that they claim is in there is a customer says that the claimant said X. And that's not hearsay. The reason that hearsay, you never exclude hearsay, which is a statement of the opposing party. That's always admissible as an admission. The claimant's brief says, but she never admitted it. But that's not the standard.
Well, the hearsay statement is not what she said, it's what the customer said.
The customer saying what the claimant
Okay, that's
said.
fine. What she said wouldn't be hearsay, but that doesn't exist unless the customer says it. So we have to determine whether it's non-hearsay or if there's an exception to the customers. And I don't dispute that the form was properly admitted as a business record, I'm not really sure that's at issue. What's at issue is what's contained in it and what it can be used for. It's being used in this case for finding of misconduct.
Well, but the business record is what allows the customer said X. That's what allows that to come in.
So no matter what the business record says, as long as it's admissible as a business record, you can't have any other evidentiary objection?
It depends. So in the Harris case, all right, I'll rely on Professor Earhart, who does a better job explaining evidence. But the point he makes is, and he uses this example, he says, if there's a business record that then says that a bystander heard X, right, or a bystander said X, that bystander's statement has to be met by an exception to the hearsay rule. Okay? It's not saying that you have to establish that bystander said, because that's within the business record. And what the bystander, or in this case, customer said, is what the claimant said. And the claimant can stand and go before the judge of compensation and say, I never said that. And then the judge gets the opportunity to weigh that and determine whether it was said or not. But the fact that a customer reported it, that's the essence of the business record.
Well, I mean, do we have to find that she was fired for misconduct or that she committed misconduct?
Well, it's not briefed, but it said the 440 says that you can withhold if you are terminated for misconduct. So let's not use it based on somebody's words, right? If somebody is terminated because they're committed theft, do you have to prove the theft, or do you have to prove termination for theft? Now, the statute says an employee that is terminated for misconduct is not entitled to benefits. And the judge of compensation claims in this particular case said that the hearsay didn't matter because it was what the employer understood and the basis for the termination. It doesn't expressly say this, Judge, but it seems to suggest that the judge of compensation believed that you had to prove that she was terminated for cause.
So the fact of misconduct is essentially irrelevant as long as the employer says that they committed misconduct?
Well, I think though they have to prove that that's the basis for the termination.
But what would stop every employer carrier in a long or extended TPD case to say, well, let's terminate them and call it based on misconduct and we'll escape that liability?
Well, because I think there would still have to be evidence of the basis for the termination. And in this particular case, again,
so essentially the truth of the misconduct firing. So you're going back to the substantive nature of the decision.
Well, not necessarily, because if in this particular case, though, again, it's what the claimant said, and that's what makes this weird. If for instance, there was something in this record that says a customer saw Mrs. Hauser stealing, and you said that you were going to terminate based on her theft, that's probably hearsay, okay? But the fact that the basis of the termination was inappropriate comments that had been warned twice prior to, that's why it's her own statements. That's why it doesn't matter, because that's admissible as her own statement. And Judge Winokur, you asked the question, well, what happens if there's 5 different, customer complaints, employee complaints, phone-in complaints about an employee? Do you have to call those 5 people? I don't think so, because if taking in customer complaints is part of the business records, and that was what was testified to by the individuals that the employer carrier called, if that's part of the process of handling complaints, then it comes in as a business record.
Well, but in cases where the claimant says that never occurred, I never said that, at that point, doesn't the arguably burden shift kind of back to the employer to say, well, we're, you know, in order to get, you know, to prove our case or prove misconduct, the truth of the misconduct termination, we have to put on additional evidence.
But again, I don't think it makes a difference in this case because, again, what you're dealing with is her own words. So let's just use this as an example. If the case is remanded, and I think if it's remanded, it has to go back for another hearing where that evidence is excluded, okay? Or the court says you have to have somebody testify. And they get this person to come in and say, I heard Dorothy Hauser say X, Y, Z about Mexican, whatever the case may be. And she stands up and she says, I never said that. Aren't we exactly where we are now, where the judge is going to weigh the credibility of that testimony? And the judge said, here you have a woman who has twice before used and admitted that she used inappropriate comments against minorities, who's saying, I didn't do that now that you're firing me. So we're back at the exact same place where the judge has to weigh the evidence. And the judge found in this particular case that there were vague recollections. Well, I think I might remember, that's kind of the testimony. I think I might remember what this particular conversation was. But again, she denies it. And the reason, again, why the evidence code allows statements into evidence of the opposing party is that that person is there in court and can always say, I never said that. And then it becomes a question of the judge weighing the evidence and determining the credibility. That's why statements of party opponents, or depending upon how you phrase them, admissions of party opponents, are admissible. Because the other side is there, the litigant in court that can say, I never said that. Of course, again, the judge said, as he found, she's going to deny this. Because this isn't simply a warning, hey, last chance. This is your pink slip, in essence. So of course she's going to deny it, but the judge said, and I think he said, that was clearly made to protect her character. So because, again, there wasn't an abuse of discretion with respect to the trustworthiness aspect, because the business record contains a statement that was made by the claimant, we believe, the employer carrier believes that there was no error and that the court should affirm. I have 2 minutes left if there are questions, otherwise I'll wrap up. Thank you.
To answer your question, they have to prove misconduct. They can't just think it was misconduct. They got to prove it. And what
So it says, if I recall what your colleague said, that you have to prove termination for misconduct.
Yes.
So you don't just have to prove termination, you have to prove actual misconduct?
Yes. Because otherwise I could say anything's misconduct. And it's not an admission. Isn't an admission if claimant said to somebody else later, yeah, I made that statement? That's an admission. This isn't an admission here. There's no evidence, no admissible evidence that this claimant made this statement. It's only this hearsay. And then the comment about 21 days because we don't know how to, what did they do during the 21 days? When the manager terminated the claimant, she didn't know anything about the incident. The co-employee was never contacted. They did nothing for 21 days. I mean, it's just, somebody gets terminated because of an anonymous call from somebody, and that's misconduct, and they lose temporary partial disability. I don't see it. Thank you.
Thank you, counsel. Thank you both. This court will stand adjourned.